I leave you with this quote from On Leadership from General Norman Schwarzkopf. Leadership is a combination of strategy and character. If you must be without one, be without the strategy. Thank you. Which brings us to the election of the vice chairperson. I will call for nominations for vice chair.
I would like to nominate
You're there.
Jim Jinks.
I second that.
Are there any other nominations? Any other nominations? Any other nominations? Nominations are hereby closed. I will call for a vote. The motion is to elect Jim Jinks as the vice chairperson. All those in favor? The vote is unanimous. Thank you. Congratulations, Mr. Jinks.
Just
Go ahead. I'm sorry, Jim.
okay. Just a few words, if anyone can hear me.
Absolutely.
I mean, I'll be upstaged by Peter very often, so I'm used to this. But just want to say that it's an honor to be elected vice chair, and I'm looking forward to working with everyone. I've enjoyed working with my Republican colleagues over the last 4 years. I know we'll work well together. We do have a great deal, many issues and challenges ahead, and I think we'll meet those and work well together. So just looking forward to getting to work. Thank you.
Thank you, Mr. Jinks. In your packets, counselors, you have the town council rules of procedure. I would like to, there are some changes that I would like to propose that I will circulate via email. And it is the intention then to vote on the rules of procedure for the January meeting, if that is okay with everyone. I also have in your packets, you have the announcement of the council committees and liaison assignments that we all agreed upon previously. Brings us to item 2D, which is the approval of the schedule of the regular meeting dates for calendar year 2024. Mr. Jinks, if you would do the resolution, please.
Be it resolved that the town council approves resolution number 120423-1. Be it resolved that the town council approves the following meeting dates for the 2024 town council regular meetings. All meetings are held in council chambers on the second Tuesday of each month at 7 o'clock unless otherwise indicated. I don't think we need to list out the dates.
And the dates are included. Do I have a second? Thank you, Mr. Walsh. Any discussion? The dates are established in the packet constitute the second Tuesday of each one of the months, with the exception of January. We moved January to the third Tuesday of the month to accommodate staff. Normally, our agenda prep is done on the Monday before, which would be January 2nd. And I don't think any of us wanted to do January 2nd. So to afford the staff some additional time, we're moving the meeting back 1 week, and the January meeting will be the 16th. Further discussion? Mr. Veliver.
Thank you. Just a point of order, on 2C, we don't have that in our packet.
Oh, okay.
The appointments.
The liaison. Okay.
Oh,
Yep.
Perfect.
Thank you. Any further discussion on the dates? Seeing none, all in favor? Motion passes unanimously. Which brings us to our first adjournment of our organizational meeting. I will accept a motion to adjourn.
Second.
Mr. Slocum and Mr. Jinks. All in favor? We are adjourned. Couple ounces less, maybe. The special meeting of December 4th, 2023 will dispense with the roll call and the Pledge of Allegiance. And I have two public hearings to call for. Thank you. All right, so we have two public hearings to call for. Be it resolved that the town council approves resolution number 120423-1. Be it resolved that the town council will hold a public hearing at 7 p.m. on Tuesday, December 12th, 2023, in council chambers, Town Hall, 84 South Main Street, Cheshire, Connecticut, to consider the town of Cheshire's withdrawal from South Central Health District. And be it further resolved that the town manager shall cause a notice of said public hearing to be posted and published according to law. And be it further resolved that the date, time, and place, or any further postponements thereof, shall be determined by the town manager with the approval of the chairman of the council. Thank you, Mr. Jinks. Since this is a call for public hearing, we will dispense with discussion and go straight into a vote. All in favor? Opposed? The vote is 6-3 with Mr. Slocum, Mr. Walsh, and Mr. Velaber in opposition. The next call for public hearing, be it resolved that the town council approves resolution 120423-2. Be it resolved that the town council will hold a public hearing at 7 p.m. on Tuesday, December 12th, 2023, in council chambers, Town Hall, 84 South Main Street, Cheshire, Connecticut, on the consideration of the town of Cheshire rejoining the Chesprocott Health District. And be it further resolved that the town manager shall cause a notice of said public hearing to be posted and published according to law. And be it further resolved that the date, time, and place, or any further postponements thereof, shall be determined by the town manager with the approval of the chairman of the council.
Second.
There is a resolution and a second. All those in favor? Opposed? Vote passes by a vote of 6-3. Mr. Slocum, Mr. Walsh, and Mr. Velaber have opposed. Which leads us to our esteemed town attorney, Mr. D'Onofrio. The meeting is yours, sir.
Good evening, everyone. So what we're going to do tonight is we are going to cover a summary of the Connecticut Freedom of Information Act, a summary of the pertinent provisions of the Cheshire Town Charter, the Town Code of Ethics, and some of the key charter and statutory provisions regarding the Town Health Department, since that issue is the substantive topic on your agenda tonight, the public hearings. Now, I want to emphasize that nobody expects anyone, whether you're an incumbent or whether you're a new council member, to remember everything that we talk about tonight. Most municipal officials don't have a very significant grasp of the details of the Freedom of Information Act. They know the basics. We're going to go a little bit deeper than that. But the main thing to take away from this is if you ever have a question about the charter, the ordinances, the code of ethics, any legal issues, I'm always available to answer your questions. Likewise, if after tonight you decide that you want additional presentations on any of these subject matters, we can certainly schedule that, okay? So let's start with the Freedom of Information Act. Okay. What we start with when we talk about the Freedom of Information Act is an understanding of what the act is and what the act isn't. And the act very simply covers two things: public meetings of public agencies and disclosure of public records. It's not about anything else. It's not a question and answer statute. In other words, if someone comes to a meeting and they have during public comment a question for you, you may, as a courtesy, answer the question depending upon what the topic is. And there may be reasons not to answer it, because if it's something that's not on the agenda and you get into a detailed discussion, then you've deprived the public of the opportunity to participate in that discussion because it's about something that's not on the agenda. So typically I discourage any kind of a back and forth, give and take during public comment of a public meeting for that reason. But when we talk about public agencies, okay, the town council is a public agency. Every board, commission, and committee of the town of Cheshire is a public agency. Every subcommittee of the town council, we have those committee assignments. You are, as a subcommittee, a separate public agency from the town council. So all of the provisions of FOIA apply to you, regardless of whether you're meeting as the council or as a subcommittee of the council. And the basic tenet of the act when it comes to public meetings is that all meetings of any public agency shall be noticed and convened as public meetings. Only after being convened in public can you become an executive session, and then only by motion. And we'll talk specifically about what the proper topics are for an executive session and how you go into executive session. Okay. But start with that core premise. The only time you do any business is when you are at a properly noticed, properly convened meeting. Properly noticed means that a notice identifying the date, time, and place of the meeting has either been filed as a notice of a regular meeting, and we'll talk about how by January 31st, you have to file with the town clerk your schedule of regular meetings that you approved tonight. And then a special meeting, which has to be noticed upon 24 hours notice in town clerk's office. So only when you have a properly noticed meeting, and then only when you have a quorum. Okay, so a quorum of the town council is 5. And there's certain things that you can't do with less than 5 affirmative votes, and we'll talk about that momentarily as well. Okay, with regard to public records, It's very simple, okay? All records or files in the possession or control of the public agency, which is the town of Cheshire. The town of Cheshire, the town government, all of the departments, all of the offices, all of the boards, commissions, committees, elected, appointed officials, and employees. That's the public agency for document purposes. So all records or files that are in the possession or control of the town of Cheshire, which relate in any way to the conduct of the public's business, are presumed to be public. So what that means is on demand, someone can ask for the town to make available for inspection the public records, make available for copying the public records, or provide copies of the public records, unless the requested materials fall within one of the exceptions under 1-210 of the general statutes. And we'll talk about that. Okay. So public meetings of public agencies, public records, that's it. Okay. Now, the act is enforced and administered by the Freedom of Information Commission. They sit in a shiny, relatively new building up on Capitol Avenue in Hartford. They have a very robust staff that's comprised of attorneys and administrative personnel, and they process thousands of complaints on an annual basis. Anybody that claims his or her rights under the act were violated, whether it's because of something to do with a meeting or whether it's because of a denial of a request to produce public records, can file a complaint within 30 days after the act complained of. The exception to the 30-day rule is with respect to secret meetings. So let's say, for example, you have a meeting tonight, right? Right now, you're in a special meeting of the town council. Special meeting, you cannot amend the agenda. Regular meeting, you can amend the agenda upon 2/3 vote to add whatever you want. Special meeting, you cannot add anything to the agenda. So let's say tonight you decided you wanted to have an executive session. That would be an illegal meeting, a secret meeting, because there's no executive session on the agenda, and you cannot add an executive session to the agenda because it's a special meeting. So 30 days from now is January 3rd. That would not be the deadline for the entire world to file a complaint against you for that illegal meeting because it was a secret meeting. So not until, under the statute, the complainant has actual or constructive notice. So if somebody goes on Facebook and reads in June of this year, I can't believe that council had an executive session. We don't know what they talked about on December 4th. And they go file a complaint. FOIC is going to accept it when they go up and testify under oath. I didn't find out about the secret meeting because it wasn't on the agenda. There was nothing in the minutes about it. I wasn't there. It wasn't until I saw something on social media. So that's the only exception to the 30-day rule. I told you what a meeting is, and I'm going to tell you what a meeting isn't. Okay? There's basically 7 types of non-meetings. The first, and these are all from the act. You have these, the materials that I've given you tonight, keep them. Okay? Use them as a resource, but don't think that every single scenario is covered. If you ever want to see a terrible website, go to the Freedom of Information website. In order to find a case, you got to read every case. There's no search mechanism. There's no sorting. There's no filtering. It's very, very primitive. But I read the cases when they come out. There's Freedom of Information advisory opinions. There's formal FOIC decisions. And then there's appeals to Superior Court. Okay? I read them. I've been doing FOIC work on a regular basis for 30 years. Okay? So there's all kinds of nuances and all kinds of twists and turns in the FOIC law. It's if you don't do the work on a regular basis, or sometimes even if you do, you really pull your hair out trying to figure out what a decision is going to be, because you would think that there'd be some interest in having uniformity, but the reality is that every case turns on the facts of the particular case. Okay? So these statutory exemptions are in stone. You don't have to worry. If you do one of these things, it's not a meeting. A chance meeting or social meeting, neither planned nor intended for the purpose of discussing matters relating to official business, right? It's called the cocktail party exemption. That came from and then the FOI came out of Watergate in the 1970s, back when there were cocktail parties. Okay. Really what it is, the chance social gathering, right? What you had tonight before you convened the meeting was not a chance social gathering. You were all invited, but it wasn't intended for the purpose of discussing official business. It was intended for the purpose of welcoming the new members of the public agency. If you go to a tree lighting, if you go to a memorial service, any kind of public outing that you go to, a parade, and you're all together, you don't have to worry about that being declared to be a meeting. So that's a non-meeting. Strategy and negotiations with respect to collective bargaining and collective bargaining sessions are not meetings. So you don't need to notice them. You don't need to post them. You can meet for strategic purposes. You can meet for negotiation purposes. It's a non-meeting. Caucuses, okay? So the 3 Republicans aren't a quorum, right? So you could meet even without the caucus exception. The 1, 2, 3, 4, 5, 6 Democrats, you would be a quorum, but if only the 6 of you meet, it's not a meeting. You can't invite somebody outside of the caucus into the caucus, because then that causes it to be a meeting, okay? So you can caucus as much as you want about whatever you want, and you don't have to worry about an FOI issue. We don't have any single member agencies that I'm aware of. Some of my towns do. Some of my towns have 1-person committees because they can't get people to volunteer. Okay. 3 more. Personnel search committee for executive level candidates. Those are non-meetings. Communications limited to notices of meetings and agendas are non-meetings. And a quorum of the agency who are present at any event which has been noticed and conducted as a meeting of another agency. So if all 9 of you, 8, 7, 6, 5, a quorum, come to a building committee meeting, we don't have to notice that as a joint meeting unless there's going to be items on the agenda that you're going to discuss as a public agency with the building committee. Okay? If you all want to go and observe, having a quorum doesn't convert it into a meeting. I mentioned regular meetings and special meetings. There's 3 types of meetings: regular, special, and the dreaded emergency meeting. I say dreaded emergency meeting because FOIC does not like emergency meetings because there's no notice required. Okay. And you really better have an emergency if you have an emergency meeting and somebody files a complaint. So the regular meetings, you've already approved your schedule for 2024. Those will get filed with the town clerk. You'll be good to go. Special meetings, I told you, are meetings that are every other meeting. Every other meeting is a special meeting. Every meeting other than a regular meeting is a special meeting. Okay. So 24 hours notice. You can only do the business that's on the agenda. You cannot amend the agenda. Emergency special meeting is a special meeting, except it becomes an emergency meeting because you didn't give at least 24 hours notice. All right. So like any other special meeting, you can't add anything to the agenda. Here's some additional details for you about regular meetings and the notice of regular meetings and how to amend the agenda. A lot of this stuff you don't have to worry about. Town staff has to worry about it in terms of agendas and meeting notices. And if somebody signs up to receive a copy of every agenda for every meeting, there's a statutory provision where anybody can do that. Typically, when you have a regular meeting or a special meeting, the minutes of the meeting have to be posted in draft form within 7 days of the meeting. If you have an emergency special meeting, it's 72 hours. And again, I didn't really go into the minutes that much because it's town staff's worry, not yours. Public records. Okay. There's many more complaints at the FOIC. I would say it's probably a 3-to-1 ratio, public records to public meetings. Most of the complaints about public meetings have to do with public agencies not moving to go into executive session correctly, or not having an executive session on the agenda, or going into executive session for an illegal purpose. So why don't I talk to you about executive sessions for a minute, okay? So an executive session, just to be clear, is a non-public discussion by the public agency. And under FOIA, there are very limited circumstances under which you can go into executive session, okay? And these are in the very first chapter of the Act, in the definition section. And the first reason to go into executive session is to discuss the hiring, firing, or performance of a public employee. So if you want to go into executive session to talk about that particular type of personnel matter, then you have to put on your agenda that you intend to convene an executive session upon 2/3 vote to discuss the performance, hiring, or firing of the public employee. And you have to notify the public employee that you intend to discuss them in executive session, because under the Act, the employee has a right to require, not request, require that the discussion be in public. Okay? The second basis for convening an executive session is to discuss pending or threatened claims or litigation in which the agency is a party. It's pretty straightforward. If you've been sued, you can convene an executive session to talk about it. If you've received a letter from someone telling them they have a claim that they intend to assert, whether it's in a lawsuit or an arbitration proceeding or some other type of formal adjudicative binding dispute resolution process, you can convene an executive session. If you're not a party to it, or it's not really a claim, it's just somebody sent you a letter because they're unhappy about something, you can't talk about that in executive session. Okay? The third type of proper executive session topic involves matters concerning security strategy or the deployment of security personnel or devices affecting public security. So say, for example, you wanted to talk about what type of ballistic glass should be installed in a town building. You can go into executive session to talk about that. Let's say you wanted to talk about different security options in town hall, whether it be a guard, security cameras, whatever. You can go into executive session. I mean, a lot of this stuff is kind of obvious, right? It's not in the public's best interest for the bad guys to know what your plans are for security, so you should be able to talk about that behind closed doors. Discussion of the selection of a site or the lease, sale, or purchase of real estate. When publicity regarding the site, lease, sale, or purchase, or construction would adversely impact the price of the site, lease, sale, purchase, or construction. So, you know, if you're thinking about buying a piece of property, if you're thinking about selling a piece of property, if you're thinking about leasing a piece of property, or you're in negotiations and you want to talk about it in executive session, again, it's in the public's best interest for you to financially protect the public. And the best way to do that is for your negotiation strategy not to be public. Okay? So that's a legitimate basis for executive session. And then the last purpose, again, those four reasons. And then the last is a catch-all, and it's discussion of any item that would result in the disclosure of public records exempt from disclosure under 1.2.10. 1.2.10 is the section of the Act that contains, 40 different exclusions to the disclosure of documents. Everything ranging from preliminary drafts to information about minors, to records of law enforcement officials used in an ongoing investigation, including signed witness statements. So there's a variety of documents that you can protect from disclosure. Most of them involve either a public health and safety concern or financial, proprietary, confidential, trade secret type information that you're looking to protect, operational specifications for security systems, engineering and architectural drawings for correctional facilities, adoption records, records about, investigating employees for certain illegal conduct, tax returns, and various financial records. So if you were going to have an executive session to talk about those records, information in those records, then you would simply say on the agenda, upon 2/3 vote, convene an executive session pursuant to 1-200E to discuss information protected from disclosure under 1210B. Right? So public records, okay? Again, you start with the premise that if it's here in any form, whether it's a piece of paper, whether it's an email, whether it's a text message, whether it's some tape recording, videotape, whatever form it's in, if it involves the people's business, you start with the premise that it's a public record. Then what happens is we get a FOIA request, and depending upon the nature of the FOIA request, town staff will route it to whichever department is likely to have the responsive records. Once in a while, if there's a question about what should be provided, if there's a question about an exemption, it'll come to me for an opinion. But the law is within 4 business days of when the request for public records is received, we get some kind of response out. You don't have to produce the public records within 4 business days. We get probably 75% of the FOIA requests we get from lawyers here in Connecticut tell us that we have to produce the records within 4 days. That's not the law. The law is if you're going to deny the request, you deny it within 4 business days. However, recent case law says if you don't respond within 4 business days, the request is deemed denied. So we, as a courtesy, will acknowledge the receipt of the request. If it's overly broad, we'll usually try to get the requesting party to narrow it. If we get a request that says all documents involving town council business, and you laugh, we get requests that are pretty broad. Then what we'll do is we'll say, we like to use search terms, and we like to know how many years you're looking for, because we are subject to record retention laws. I just had an FOI case for Berlin where the record request went back to 2008. And we said, here's everything from the last 6 years. That's all we have. He filed a complaint. He lost. Okay. We had our IT director testify that we have a record retention policy. It's consistent with what the state library requires us to have. It was about a 15-minute hearing. So when we get these requests, it's not that we're looking to avoid complying with them. We're looking to minimize staff time doing things that are unrelated to what the requester really wants. So we try to get the requesting party to tell us, could you be a little bit more specific about what you're looking for? Many times we'll get a request, if there's an auto accident, it could be something we don't even know about that has nothing to do with the town. A plaintiff's personal injury lawyer's paralegal submits a request for traffic records in a particular neighborhood, and we have no idea what it's pertaining to, and we kind of figure it out that they're looking to sue somebody for an auto accident or something. Okay. So keep in mind, like I said, if it's here in any form, it's fair game unless it's exempt. But we're not required to create documents. Sometimes we get these, for revaluation, for example. Somebody will send an FOI request asking us for a list of all capes built between 1978 and 2015 and what the values were the last 3 you get requests like that, and it's from people gathering information. When you have construction projects going on in your town, like you do with the 2 new schools, you'll get requests from construction industry trade associations looking to, how many union workers are on your job? We're in design development. We don't have any union workers, right? but you don't have to create a document. That's not what FOIA is intended to do. FOIA is intended to shine a light on how the public agency is conducting public business, not force you to do more public business in response to a request. Okay? If somebody wants to show up and ask to look at records, they can do that. If somebody, however, wants to request copies, that has to be in writing. So no written request to inspect. They can just show up. I never really cared for that because somebody could be in the middle of who knows what project. And in a lot of small towns like Cheshire, you don't have surplus staff floating around waiting for random people to show up at the desk. But that's the law, okay? And so what we do when somebody shows up and says, hey, I'd like to request records, is we say, okay, give us your name, your telephone number, your email. If someone wants to come in and look at a building permit, someone wants to look at a certificate of occupancy, something that's, you know, readily available, that's fine. If somebody comes in and says, I want to look at every email from this department to this person in the last 5 years, then we're going to tell them they need to come back. We'll give you a call when they're ready. We can provide, I don't want to go too much into detail with you on the form of the way we provide documents because you're not really involved. You won't be involved in putting together the documents, but you should know, you know, generally speaking, that we can provide documents in whatever format we want. So, you know, I've had FOI requests where people come in and say, you know, I want a hard copy of everything. And I say, here's a flash drive. No, here's the flash drive. That's compliant. You don't have to inconvenience yourself. You can charge 50 cents a page for a hard copy. But again, you know, sometimes I've had, especially in the construction projects, you know, you get an unhappy bidder and they want copies of everybody else's bid. And it could be, you know, a couple thousand pages of documents. You don't have to go through the expense of copying them and stapling them and do all that stuff. The only exception is if somebody wants a certified copy. Somebody says, I want a certified copy of a public record, we have to give them the certified copy. Again, the definition of public record includes every kind of ESI, electronically stored information, all computer records. No fee for inspection of records. You could charge 50 cents a page if they ask for copies, or if they come in and inspect and say, I want a copy. But if somebody shows up and they have a portable scanner and they say, I want to inspect records, we can't charge them anything for that. I told you that we frequently are told by requesting parties that we have to produce records within 4 business days, and that's not the law. So what is the law? In true Connecticut form, the law is you have to promptly provide the records. And the commission has, I would say, consistently defined promptly as 30 days. You may have read about Hartford and Bridgeport getting in trouble because it took them 2 years. 2 years isn't promptly. You know, I've had cases, especially during COVID, where it took 3 or 4 months and we had to testify at the hearing. Why did it take 3 or 4 months? What did you have to do? And they said, you know, we weren't in the office every day. And then the 2 of us weren't in the office at the same time to coordinate. And there was a lot of back and forth, and the commission was okay with it. But, you know, there's no hard, fast rule. But again, promptly, usually you can do it within 30 days. You know, once in a while, we have people that don't want to pay a marshal $60 to serve a subpoena. We had a trial that I went to court in October. The town wasn't a party. It was a dispute between 2 private property owners, and somebody did an FOI request because they wanted the documents for the trial. The trial was like on a Monday, and the FOI request came on a Thursday. And I called them up and said, serve a subpoena, you're not getting any documents next week. Okay. But we do try to communicate with the requesting party. You know, if we're going to withhold documents, if I'm involved, I'm telling them the exact reason for it under the statute. So if they want to file an appeal, they can file an appeal. email, 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 email. Email's a big, big problem. And I'll give you 3 examples. I could give you 333. I'll give you 3 examples. Somebody sends an email. I'm not going to pick on, we'll call her Arnell. So I don't pick on either of them. They send an innocent email, okay, with something from the town attorney of substance, some memo about some opinion. And it's just being communicated to you. It's okay. Okay. You're being informed about something that's upcoming at a meeting. Let's say you're going to be meeting to talk about a proposed lease, and the town attorney did a memo on the lease, and that's being shared with you so you can be prepared for the meeting. But then somebody replies all, and you have a discussion. That's an illegal meeting because you can't possibly notice to the public that you're going to be discussing this topic. It's impossible for the public to participate or observe that meeting. That's an illegal meeting, okay? If you get, I love him, he's a great guy, he knows more about FOIA than probably anybody, Tom Hennick. He's the public information officer at the FOIC. He's been there for about 30 years. He's not a lawyer, but he goes around to public agencies and he does training. If he was sitting here, he would say that if 2 of you email each other about public business, that's an illegal meeting. That's not my position. My position is a quorum can't email. And if there's a deliberate effort to circumvent the quorum, so let's say you've got 9, so 5's a quorum, right? So you've got 4 on one, 4 on another, and then 1 emailing somebody a second time. It's obvious, and they're in proximity to each other. It's obvious you're trying to circumvent the quorum, right? And you're having a legal meeting. That's on the meeting side. The document side is where the real headache is. I mean, I can't tell you how many times I've had FOI complaints, not in Cheshire so far in 2.5 years, but in other towns, FOI requests for all email and text message communications between all members of a town council or a building committee or a board of ed or a board of finance about a particular topic. And then, somebody produces an email and then everybody else says, I don't have any. And then I end up at a hearing and then it's, oh, I didn't understand that my personal email matters. If you're doing business on a personal email, it's the public business and it becomes a public record. If you're messaging somebody on a personal phone, okay? If you're on Facebook, Instagram, Snapchat, Twitter, whatever your preferred social media outlet is, and somebody says something about, oh, gee, I didn't like your first town council meeting, that lawyer was a jerk, and then you message them back and you start having discussions about town business, you're conducting town business, and you're doing so at your own peril because you're now creating documents that must be retained as public records. And the reason that I say it this way is because the town has an IT professional. The town has a record retention policy. The town can control town email accounts and how records are retained. If you do town business on a personal account, the town has no control over that, but the town has the ability to obtain those records from you. You can go text messages. I've had FOIC people tell me, go tell the members of the agency to contact their wireless carriers to get those messages. Okay? So they take the position that if we can ask somebody for them, then we have the ability to get them, and it doesn't matter if they're on a personal account or not. So just, be very careful. And again, 99% of the time, you're not doing anything that you wouldn't want anybody to know about. It's just a retention issue, and you don't want to be in front of the commission explaining that you didn't retain it. especially now that the whole world knows you have training. So this is what I just went over, the retention. Okay. Retention policy is another state of Connecticut beauty because it's based on the nature of the communication. So it's not all emails must be retained 7 years. Is it routine correspondence? Is it with regard to a meeting? Is it with regard to a capital project? It's, there's 30 different types of records as far as the state library is concerned. Litigation hold. If we get sued, okay, and we have a conversation about, well, let me take a step back, okay? One of the exemptions under 1210B of the Act is attorney-client privileged communications, okay? So the organization, which is the public agency, okay, is my client. The municipal corporation is my client. Those public agencies for which I've been engaged to provide services are my clients. The individual members of the public agency, I don't represent you individually, okay? When you have a conversation with me about town business, you're doing so in your capacity as a member of the town council, and therefore it's subject to the privilege. If you ask me for a legal opinion, if I give you a legal opinion, those communications, email, text messages, voicemail, letter, memo, phone, whatever, it's all privileged, and none of it gets produced under FOIA, okay? So if you're worried about something, if you say, gee, I think this board may be doing something wrong, or I think, we may have a problem with this lawsuit, we can have that conversation in executive session. We can have that conversation on the telephone, whatever, and you don't have to worry about FOIA. But once there is a claim, whether it's, notice of an audit, whether it's a mediation, arbitration, CHRO, lawsuit, ethics, FOIA, any type of claim by anybody against the town, then we have an obligation to put a litigation hold on all of those records, even if the retention period has expired. And again, that's something for you to know as town council members. In practice, it's not something that you really will be involved in, other than if you do have a bunch of emails or text messages on your personal devices and we get sued, don't go deleting anything. So the way it works is someone who feels that their rights have been violated because they haven't been provided with the public records they requested, or they feel that the meeting requirements haven't been complied with, they file an FOI complaint. There's a form on the FOIC website, not to pick on FOIC more than I need to, but the form's awful. It's awful. I mean, you got to look at it. It's like you don't get to provide any information. So most people don't use the form. You can write a letter. You don't have to be represented by counsel. It can be an email. It's very informal in terms of filing the complaint. After they file the complaint, about a month or two afterwards, the FOIC will send a copy of the complaint, in this case, to the town. So many times an FOI complaint's been filed, we don't even know about it. And then in that letter, they will assign a staff attorney at the commission as an ombudsman. And the role of the ombudsman is to resolve the dispute. So if it's a records dispute, I'll get a call saying, they want this record, why didn't you provide it? I had one today, not Cheshire, another town. We got a hearing coming up. Will you provide the record? No. Why not? Because it's a signed witness statement. And the statute and every case interpreting the statute say signed witness statements are exempt. Okay. Is it a witness statement or it's a signed witness statement? Okay. Let me talk to the complainant. She talked to the complainant withdrew the complaint. Okay. So a lot of the record stuff can be resolved. I had another one where they wanted all kinds of special ed records. And I said, there's FERPA issues, student confidentiality issues. We're not producing them. And the FOIC said, redact the records. So I redacted, probably without exaggeration, I don't know, 4,000 pages. And you have to hand deliver them, and they have a year to make a decision. I hand delivered them in August of 2022. No decision ever came. So sometimes that's part of the outcome, is they'll redact the records. But, you know, they try to resolve it. You get one chance to resolve it. You don't resolve it, you get to go to a hearing. You only get an hour and a half for the hearing. Sometimes if it's very complicated, they'll give you 3. But that's the process. If they find that you violated FOIA, they can fine you. Fines are very unusual. Fines are for repeaters, okay? If it was an illegal meeting and you took action at the illegal meeting, they can declare the action to be null and void. In my earlier hypothetical, where you had a illegal secret executive session tonight, because it's a special meeting, it wasn't on the agenda, you can't add anything to the agenda. What they would do in that scenario is make you write minutes of what you talked about in the executive session. So the public finds out what you did, and they would tell you, don't do this again. That's typically it. You know, for documents, it's usually produce the documents. So why did I talk about that for 40 minutes? Well, because more often than not, the time that is spent responding to the complaint is disproportionate to what's required to actually comply in the first instance. And we don't want to get bogged down with FOI complaints, okay? A couple little bonuses for you here. A lot of times people tell me, oh, it's a personnel file. It doesn't have to be produced. That's actually not the law, okay? The only time that you don't have to produce part of a personnel file is if the production of the information would constitute an invasion of the employee's personal privacy. It's actually a pretty high standard. So more often than not, if somebody asks us for a personnel file, we have to produce it. Talked about attorney-client privilege. Talked about pending claims, preliminary drafts. Okay. Any FOIA questions?
Yeah, exactly. Seeing none, I have a couple, Jeff, that I just, couple clarification. Hopefully it's just clarification more than anything else. Let's see where my notes were here as we went along. Emergency special meetings. Should there only be one topic on a emergency special meeting? So should you just, you know, whatever, pick a hurricane relief? You know, would that be the only topic then on the agenda? Obviously, you don't want to lengthen the agenda or to include other business on that agenda, correct?
Correct. I mean, I've had emergency special meetings to buy a snowplow, to buy a fire truck. I really can't think of other emergency special meetings where they're just, you know, they really needed to do it. I mean, the problem that FOIC has with emergency meetings is a special meeting is 24 hours notice.
Yeah.
I mean, how many things can come up where it's 10 a.m. and you're like, we need to have a meeting at noon? Because how could you even gather a quorum of the public agency on such short notice? That's what the commission typically says when you go up there trying to defend an emergency special meeting. So I would say the answer to your question is, if you have multiple emergencies that are legitimate emergencies, fine. But it does kind of beg the question, gee, when did you first find out about these, and why couldn't you just notice it 24 hours in advance as a special meeting so that the public would, you know, see an agenda? I mean, the reality is most of the time when you notice a special meeting, unless people are looking for it, they don't know about it anyway. You know, even with putting agendas on the website, unless somebody's checking every day, they're going to miss a special meeting. A lot of times we'll see special meetings get set at a regular meeting. Somebody will say, oh, we're going to have a special meeting to talk about this because we need to make a decision by this date. And our next regular meeting is until after that date. So then anyone that's at home or in the audience who's interested, they'll check the website, they'll keep an eye on it. But emergency meetings, I can't really imagine where you'd have many items on that agenda. So if possible, I would love to see it limited to one item. But
Okay,
if you have multiple emergencies, it happens.
yeah, okay. My other question was the difference between a quorum and a caucus with regard to email or text.
Well, email, you can caucus by email. Okay. You can caucus by email. You can caucus in person. It doesn't matter. So the fact that your caucus represents a quorum is okay as long as nobody outside your caucus is on that email.
Okay,
The problem that public agencies run into with caucusing by email is when some member of the caucus forwards part of the email to somebody outside the caucus. So you just have to agree amongst each other that caucusing by email is for the convenience of the members. And if it's abused by breaching the confidentiality of the caucus, then you're gonna have to do it in person or Zoom or whatever.
okay.
But the form, it doesn't matter. You can, as long as it's just the caucus, you can do it however you want.
I think we can go into charter.
Okay. So Connecticut is a home rule state, which means that the Municipal Powers Act, which is Connecticut General Statute 7-148A, allows municipalities to adopt a charter. And not every municipality in Connecticut has a charter, but Cheshire does. And that charter becomes the organic law of the town. So unless it conflicts specifically with a state statute or a state regulation, the charter is going to take precedence. In fact, many times you'll see a statute that'll say, unless otherwise provided by charter or ordinance, here's the law. In those cases, you have a charter. Okay. And then you also have ordinances. Okay. And the ordinances and the charter are read in conjunction with one another. And there's way too much in the charter to do a blow by blow of the charter. So I picked those charter provisions that pertain specially to you, the town council, starting with section 3.1. 3.1 has the powers and the duties of the council. Okay. The council is the legislative body of the town. Town manager is the executive branch. Okay. So the powers that are vested by statute or charter in the legislative body are held by the town council. So it's not only what's in the ordinances and what's in the charter, but it's also anything in the Connecticut general statutes that just refers to legislative body of the municipality. That means town council for Cheshire's purposes. Now, the clerk of the council is appointed by you, and as I indicate, is a VIP, okay? Because the clerk maintains records of all the meetings, all the public hearings, all the votes, all the ordinances, and all the resolutions adopted. So the clerk really needs to be very accurate in creating and maintaining those records and really become a historian in terms of the doings of the legislative body of the town. I told you before that even though 5 members is a quorum of the town council, there's a couple things that you need 5 affirmative votes to make happen. One is to adopt an ordinance, and the other is to pass a resolution. Okay? So if you only have 5 people here at a future meeting, you have a quorum. You can open the meeting. However, if there's an ordinance and one person votes no, the ordinance fails. Okay? If you're looking to pass a resolution at that meeting where you only have 5 members and one person votes no, that resolution fails, even though it's a 4-to-1 vote. As you know, you make appointments to appointive boards, commissions, and committees. You determine compensation for town employees, except Board of Ed employees, based on the pay plan created by the executive branch, the town manager. Now, you understand the deal with Board of Ed, right? Board of Ed gets an appropriation of money, and then it's hands off. They spend the money, they spend the appropriation, how they deem fit. That's in the Connecticut general statutes. It's been litigated at the Connecticut Supreme Court. That's the law of the land, for better or for worse, okay? Town council has sole authority to recognize the exclusive bargaining agent for any bargaining unit of town employees. So for purposes of engaging in collective bargaining, negotiation, contract negotiation with the town's bargaining units, you guys are going to recognize who the bargaining agent is for your bargaining units. Ordinances are an important part of what you do. And of course, a public hearing is required prior to voting on a proposed ordinance. Electors, your voters in town, can propose ordinances via petition. The petition has to be signed by not less than 10% of registered voters. And if you don't adopt the ordinance that is petitioned within 30 days, it goes to referendum, unless you decide, based on my advice, that the topic for the ordinance is not lawful. And that hasn't happened in Cheshire. I keep saying, I've only been here 2.5 years. I'm sure you guys get in trouble every once in a while. But in some towns you get petitions. I had one in North Haven one year where the legislative body of the town meeting, in the budget process, eliminated a position from the budget, okay? The budget passed. Then the town meeting petitioned the Board of Selectmen to restore the position, to have a referendum, to put to the people the restoration of this position that wasn't in the budget. I opined that there was no jurisdiction to do that it was not a proper purpose for the town meeting, and the Board of Selectmen agreed, and there was no referendum, and the guy that wanted his job back didn't get his job back. But not everything that the voters would like to see go to referendum gets to actually go to referendum, because 7148A, the Municipal Powers Act, limits what you can do as a municipality. So if somebody tries to get through referendum an obligation imposed upon the municipality that isn't legal, you don't have to have a referendum on that. All right, separation of powers. Like I said, you're the legislative branch. The town manager is the executive branch. So why does that matter? Okay, so if you look at section 3-10 of the charter, you'll see that relations to administrative services. So 310A, neither the council nor any of its members shall direct or request the appointment of any person to any office or employment which by the provisions of this charter, the manager or any of his appointees is empowered to fill by appointment. Okay, so the manager can seek advice from the council regarding appointments and is required to advise the council prior to making final appointments, but you can't direct that the manager hire someone where the charter has vested that authority in the manager. Likewise, under 310B, neither the council nor any member shall give orders to any of the subordinates of the manager, either publicly or privately. So you can't go up to a department head and tell a department head how to do something, or from an operations standpoint, substitute your judgment for that of someone who reports to the town manager. So you hire the town manager. So if you want to have a conversation with the town manager about an operational issue, a personnel issue, you're free to do so. But in terms of ordering the town manager to do something on that front, you don't have the jurisdiction, okay? Chapter 5 of the charter identifies the positions appointed by the town council, how appointments are to occur sequentially, details about terms, how to fill vacancies, and other important details about appointments. So you're going to want to read Chapter 5 before you do your first round of appointments. The town manager, as I mentioned, by charter is responsible for appointing key personnel. The building official, the town engineer, economic development director, director of finance, fire chief, police chief, fire marshal, director of human services, library director, town planner, director of public works. So all that is set forth in Chapter 6. So if you're ever wondering, hey, who hires this person, Chapter 6 is going to answer that question for you. Financial responsibilities, obviously, and perhaps unfortunately, budget season's right around the corner. It seems like you end one and 3 months later it's time for another one. And Cheshire doesn't have a board of finance based on your form of government. Some towns have a town manager, a town council, and a board of finance. You don't have a board of finance. So the town council is the budget making authority for the town, and a considerable amount of your time will be spent in terms of the annual operating budget, the annual capital budget, and then at budget committee meetings prior to regular meetings of the town council. Section 7-1 of the charter sets forth the process for the budget making, and it starts with the town manager. Town manager has to present to you by March 10th a proposed operating budget, and you'll then proceed with public hearings on the proposed budget, accept it as presented or make increases or decreases, adopt the budget subject to the voters' power of referendum, and set the mill rate. And the charter contains in Section 7 the detailed sequence of events and the dates and deadlines. So that'll be something you'll want to get familiar with probably by the first of the new year. Likewise, on the capital side, the council's responsible for putting together the annual capital budget and the 5-year capital budget plan. And Section 7-2 of the charter sets forth the process for that. And 7-3 sets forth the process for special appropriations, appropriations that are not part of the annual capital budget or the annual operating budget and are going to be made from some other source, whether it's the unappropriated fund balance, whether it's from grants, extraordinary revenue, whatever. And in Cheshire, this process is anything over 250,000, but not over 500,000 requires a public hearing, and anything over 500,000 requires a public hearing and a referendum. 7-4 explains how the town borrows money. 7-7 contains restrictions on expenditures and how expenditures are authorized. 7-8 governs purchasing, including how the town procures goods and services that are required to be purchased using a competitive procurement process. And what that means is you set an annual bid limit. You set a bid limit annually. By state statute, the maximum right now is 25,000. So up to 25,000. If you adopt that as your bid limit on an annual basis, then you don't have to go out to bid unless what you're buying is being purchased with state or federal money. So, for example, on the school construction projects, because you're receiving state grants, everything you buy has to go through a competitive bidding process. Professional services go through an RFQ, RFP process. When it comes time to actually buy the trades, the materials and labor to actually build the building, that goes to a lowest qualified responsible bidder. When you use ARPA funds, federal money, you have to go through competitive procurement process, with very few exceptions for small purchases. But by and large, when the town is purchasing goods and services, it's doing so through a competitive procurement process. Conflicts of interest. So Section 9-3 of the charter cross-references the town's code of ethics, which is set forth in Section 10-1 of the charter. And what you need to know about the code of ethics is, like any code of ethics, the definitions are critical, okay? The definitions of financial interest and personal interest are really what you want to commit to memory. Because when you have a conflict of interest, it's going to be because you have a financial interest or a personal interest in something that comes before you, whether it's something that's going to be voted on, whether it's a contract to be awarded, whether it's a relationship that you're involved in. There's nothing wrong with having a conflict of interest. The trick is how you deal with it. And the first thing that you do when you have a conflict of interest, well, first of all, if you're not sure if you have a conflict of interest, call me or email me and we'll figure it out, okay? And if you do have a conflict of interest, usually the first step is to disclose to the chair that you have the conflict. And we'll figure out whether it's a conflict that you can disclose and not abstain, or whether it's something you need to completely recuse yourself from discussion and from voting. And when you recuse yourself, that means you're totally out. It doesn't mean, okay, I'm not discussing, I'm not voting, but I'm talking to other people on the council about how they should vote. It means you're totally out, okay? Because if you're not totally out and you have a conflict of interest and you try to persuade somebody to vote a certain way, that's called improper influence. That's a violation of the Code of Ethics, okay? Keep in mind that as individuals, you have no power and no authority. Under the Charter, under the Municipal Powers Act, under any interpretation of any law, you get your superpowers when you're convened at a properly noticed meeting at which a quorum is present. Once you all are together as a quorum, then you become the Avengers, right? You have all your powers and you're able to do the things under the Charter, under the ordinances, under the statutes. But without it, you don't, okay? And if you want somebody to have power, then you vote in a meeting. You put it on the agenda. I want to authorize the chairman to do X. And as long as it's lawful, as long as it doesn't exceed the powers granted by home rule under the Charter and the ordinances and the statute, then it's fine. You can delegate. You know, for example, on the building committee, eventually we'll reach a point where we need to give the chair some authority to deal with minor changes. So we'll come up with a dollar amount, whether it's 50,000 or 5,000. The building committee will say, okay, if there's an issue in the field and we don't have time for a meeting, we're going to delegate to the chair authority, right? So there are situations where you'll delegate authority to usually the chair. Likewise, if you had at a properly noticed meeting, you had an agenda item, you had a discussion about how something should be handled. Say it's a vendor issue, or say I need somebody to go to a mediation with me. You'll vote to give that person authority. So that person will come with me and have authority to do something. You'll say, okay, you can settle this case up to X dollars, okay? So there will be circumstances where you'll need to authorize someone, but absent those circumstances and absent that process of properly authorizing one of you individually, don't commit anybody to anything, okay? Because then what you're doing is personally, you're exposing yourself to individual liability, okay? Section 10-1F sets forth the process for dealing with conflicts, all right? Now, every town official and every town employee is subject to this code of ethics. It doesn't matter whether you're paid, unpaid, elected, appointed, cemetery commission, town council, it's all the same, all right? If you have any questions about it, my job is to help you steer clear of any issues with the code of ethics or anything else. So don't ever be shy. Don't ever hesitate. Don't ever call me and say, I have a stupid question, okay? Because there are stupid questions, but not about this stuff, okay? Stupid question is, should I wear a coat today? It's 30 degrees out. That's a stupid question, okay? This stuff is not intuitive. And I'll tell you something else. I'm town attorney in several towns and special counsel doing ethics work in a whole bunch of other towns. Every code of ethics is different, right? Connecticut went through this thing in 2004, 2005, where all of a sudden all the municipalities thought they needed a code of ethics. And instead of having a uniform code of ethics with uniform definitions, Everybody has something different. The processes are different. The protocol, the definitions are different. So, I had a hearing last month, and it was an ethics complaint filed by one town council member against another town, of course. And the respondent said, and he had been on the council for a long time, that he had never read the code of ethics. So the board heard that, and they were kind of like, that's not going to fly here. It's not something that takes all that much time to read. Okay. Any questions on the code of ethics? Okay. Now, public health. So the whole concept, again, state of Connecticut. Oh, I forgot. I had this map I was going to bring you that was color coded that showed which towns have their own health district, which towns have part-time health district, which towns have belong to a regional district. And as you can see, Connecticut, it's a hodgepodge, right? But it all starts with Connecticut General Statute 19A 200, which says that unless otherwise provided by charter, every municipality must nominate a director of health for approval by the Department of Public Health. And the director of health either has to be a licensed physician with a degree in public health or has a graduate degree in public health. Municipalities with populations over 40,000 have a full-time public health director, and licensed sanitarians are also required for the municipal health districts. The statutes also allow municipalities to designate themselves as having a part-time public health department if they haven't had a full-time department or haven't been in a full-time district as of January 1 of 98, when this statute was written, okay? And if the municipality has the equivalent of at least one full-time employee who performs the public health functions required by law. So the emphasis here, this is where it comes from, right? But the emphasis here is unless otherwise provided by charter. Cheshire provides by charter the two options. The manager can appoint without term and with removal powers a director of health, okay, who reports to the manager. Or the town can enter into a health district. The health district then acts as the town's Department of Health, and the director of the health district in turn becomes the town's director of health. So many years ago, the town availed itself of its rights under 6-7B of its charter and joined the Chesprocott Health District. With respect to joining or leaving, there's a typo, a healthy district. I guess it probably should say a healthy health district. The two relevant statutes are 19A 246 and 19A 241. Under 19A 246, the town, any year or every year, can vote prior to January, which means by December 31st, to withdraw from a district. And that withdrawal becomes effective the following July 1, provided the town has been a member of the district for at least 24 months prior to the vote of the withdrawal. And I put a note in here, you always have to check the bylaws of the organization you're withdrawing from to see if there's a public hearing or other requirement in addition to the requirements of the state statute. And in the case of Chesprocott, the Chesprocott bylaws required a public hearing, so there was a public hearing, okay? And by statute, upon withdrawal, the town resumes its prior status unless it joins a different district. To join a new district, you have to comply with 19A 241, which requires a public hearing to join the district. After the public hearing, the town council votes. The town council appoints someone to be a member of the district board and gets one additional representative for each additional 10,000 in population. You send a certified notice of the public hearing and the resolution approving joinder to the Department of Public Health and a couple other filings. And you make sure that the new district that you've joined has their board resolve at a legal meeting the acceptance of the town into the district, and you provide a copy of that same resolution that you filed with DPH to the new district, accepting you into the new district. So, I mean, that's the process. Happy to answer any questions about it. I know that you voted tonight to call public hearings on the withdrawal from South Central and rejoinder of Chesprocott. You know, my advice on the public hearing was I haven't seen the bylaws for South Central, and I don't want to have a scenario where we don't have a public hearing and then we get a bill from South Central because they say we didn't have a public hearing to withdraw. So it's kind of a belt and suspenders thing. All right.
Questions from the council? Mr. Walsh?
Yeah, thank you. Just a quick one. As a member of the district for at least 24 months prior to the vote for withdrawal. So if it does change at our next meeting, does that 24 months start then? Or
Well, the way that the way that I interpret that 24 months, the withdrawal from Chesprocott would not be effective until July 1. Okay. So if it was if we were sitting here on July 2, okay, then we'd have a problem. But we're not. So the 24 months is a non-issue.
Anyone else? Are we having fun yet? All right. Well, that is, Jeff, thank you. I appreciate it.
That was an
It's,
hour.
yeah,
A lot of material.
it's a lot. It is. And it gives us some good reading material for over the holidays and beyond. So, thank you for doing this on a multitude of topics. And with that, ladies and gentlemen, I'll call for a motion to adjourn. Mr. Jinks, and second from Mr. Velaber. All in favor? We are adjourned.